Michigan DUI lawyer coming to you this evening with a DUI trial update. I've been in trial all day. I'm a little tired, a little frazzled. I've been fighting this case for 25 months. And through repeated discovery demands and motions and emails to the prosecutor, I still, to this day, do not have the expert witness materials regarding the chemical test in my case. It's unbelievable. And I can't get the court to agree with me that this is a problem. So rather than talk about my case, let's talk about a different case. This is Annie Dukin. Annie Dukin was a lab analyst in Massachusetts back in 2009 when it was uncovered that not only did she not have the degrees that she claimed from Harvard, it also turned out that she was dry labbing, meaning that she was affirmatively reporting that people were in possession of certain drugs, illegal drugs, even though she hadn't run the tests. Now, Annie went to prison, and she damn well deserved to be in prison. She falsified some 34,000 cases that were called into question, and people had to be acquitted because, their state lab analyst was perjuring herself and not actually running the tests. Now, during the course of that, though, what if any one attorney had ever asked for the actual underlying scientific information pertaining to the case? Due process demands that the prosecutor turn over all of the scientific information that is in their possession if they intend to rely upon expert testimony. And the Supreme Court, back in 2009, same year that Annie Dukin went down in flames, ruled in Melendez-Diaz that we have a right to confront these witnesses in court. We have a right to the evidence, and we have a right to confront these people in court. Now, of course, the question then becomes, but the judge keeps saying motion denied to you, Mr. Mays. And that's true. I don't know what to do with that. I feel like I'm taking crazy pills or something. This is a big, important issue. And there's big, important issues going on in the state of Michigan when it comes to blood testing right now. But they're not offering me a single opportunity to even look at the evidence, and we're midway through trial. I'm going to try and impress upon the jury tomorrow and ask the judge again, strike this. If I'm not allowed to see it, it shouldn't come into evidence. If they're not willing to allow the science to see the light of day, we don't do it in secret. Strike the evidence. And if that's done, this case is done, because the entire case, after over 2 years of litigation, hinges entirely upon the non-disclosure of that information.